Welcome to part 2 of the 75 most important questions you need to know to pass your state's real estate licensing exam. So let's get started with question number 26. All of these are ways to express a legal description, except, and your answers are lot and block, meets and bounds, rectangular survey, or benchmarks. And your answer is benchmarks. A benchmark is a permanent reference point used as a reference for marking datums, not a method of legal description. The three methods of description, probably most important that you know the names of the three: lot and block, meets and bounds, and the rectangular or government survey system. Okay, our next question will be: the end of a meets and bounds land description is always a monument, B, a benchmark, C, the point of beginning, or D, a baseline. A meets and bounds always returns to the point of beginning. A meets and bounds description must always begin at the end, at the point of beginning, thus enclosing the described property. Where you start is where you finish. The point of beginning is also the point of ending. Our next question: the verification that a grantor's signature is both genuine and voluntary is, and your answers are a judgment, B, an attachment, C, a consideration, or D, an acknowledgement. And the correct answer is D, an acknowledgement. An acknowledgement is a formal declaration under oath that the person who signs a written document does so voluntarily and that the signature is genuine. The closing agency, whoever's doing the closing, is normally a notary, and that's their job, is to verify that the person signing the documents is the person that's supposed to be signing the documents. The buyer's brother didn't come in to sign for the buyer today because they weren't available. It's the person that's supposed to be signing. Okay, let's move on. Our next question is going to be: the type of deed that imposes the least liability on the grantor, the seller, is. The type of deed that imposes the least liability on the seller is A, special warranty deed, B, a bargain and sale deed, C, a quitclaim deed, or D, a general warranty deed. I'll give you a minute to answer, or a few seconds, because the answer is a quitclaim deed. A quitclaim deed carries no covenants or warranties and generally only conveys whatever interest the grantor has, if any, when the deed is delivered. It transfers ownership as well as a general warranty deed, but it makes no promises, no warranties. Okay, our next question. The transfer of any interest in a parcel of real estate is typically in a document called the A, title, B, deed, C, attachment, or D, mortgage. How do we transfer ownership? And the answer is, at closing, the seller gives the buyer a deed. A deed is the written document that transfers a real estate interest. Evidence of ownership is written in the deed. An attachment is the process of taking the person's property into legal custody by the court. A mortgage provides the security for a loan. Point being is, a deed is a written document that transfers real estate interest. We use the word title just to refer to ownership, but it's not an actual printed document. The deed is the document that we use to transfer ownership. All of these are necessary to a valid deed, except you don't need for a deed. Which one of these do you not need? A, recital of consideration. B, words of conveyance. C, the grantee's signature. Or D, delivery of the deed. Which one of these are not necessary? And your answer is the grantee's signature. The grantee does not sign the deed because the grantee receives the property. The grantee is the receiver, the receivee, the one receiving ownership. The grantee's named in the deed, but the grantee does not sign the deed. A deed is a custom written document. It names the purchaser or the grantee, but the grantee does not sign the deed. The grantor is the seller, the grantee is the buyer, the grantor signs the deed. Isn't this not like a title to your car? When you sell your used car, isn't it the seller signs the deed, then the buyer is able to take that title to DMV and re-register the title into their name. Very similar. Next question. Which type of deed is used by a grantor whose interest in the real estate may be unknown? A, bargain and sale deed. B, special warranty deed. C, general warranty deed. Or D, quitclaim deed. These are the 4 types of deeds that we can use to transfer ownership of property, typically would be used. And your answer is a quitclaim deed again. If the grantor has no interest, the grantee will acquire nothing and have no right of warranty claim against the grantor. Somebody had a relative pass away. We think this person owned this piece of land, but we're not sure. Can't give you a general warranty deed to pass ownership to you. That has all kinds of promises of ownership that go along with it. But a quitclaim deed says whatever ownership the prior owner had, you now have. If they had no interest, you have no interest. If they did own the property, you now own the property. That's a quitclaim deed. So let's move on to our next question. All of these are reasons for probate, except A, to ensure that the heirs do not fight among themselves. B, to confirm that the will is valid. C, to determine the exact assets of the deceased person. And D, to identify how the estate will be dispersed. What is not a reason for probate? And your answer is A, to ensure that the heirs do not fight among themselves. Preventing fights among heirs is not the reason for probate. To properly distribute the assets of the deceased, allocate the assets of the deceased. Okay, our next question. Good question. What limits are set by the covenants in a general warranty deed? What limits are set? A, there are no limits. B, the covenants are limited to the matters that occurred during the time the grantor owned the property. C, the covenants are limited to the matters that occurred within the last 10 years. And D, the covenants are limited to matters that occurred before the grantor owned the property. Give you a few extra seconds on this one. your answer here, this is a general warranty deed. Covenants are what promises the seller is making to the buyer. If this happens after closing, I'll make that good. With a general warranty deed, and probably one of the more important things to know, this is the better deed for the buyer to receive because it provides the most protections or most promises to the buyer from the seller. There are no limits set with a general warranty deed. The grantor defends the title against the grantor and all those who previously held title to the property. When you buy a home, you pay for title insurance at closing, one time at closing. And just after closing, they're going to send you a copy of this title insurance policy. They tell us, hold on to this title policy forever. This title policy continues to protect you well beyond the time that you've no longer own that home. It's a lifetime of protection because you've told the buyer, I'll protect the title against anything that happened in the history of ownership of this property. Anything. So that's a lot of promises you're making with the general warranty deed. The covenants are limited to matters that occur during the time that the grantor owned the property. That's a special warranty deed. We used these a lot in the past with foreclosure sales. The bank would give the buyer a special warranty deed. In a sense, the bank is telling the buyer, if while we own the property, we paid all the bills. We're not guaranteeing anything beyond the time that we own the property, but while we owned it, we paid the bills. Or maybe you're flipping the property. You bought a property 30 days ago to flip. And now you're putting on the market to sell. Do you really want to give the buyer a general warranty deed? By giving the buyer a special warranty deed, we're telling the buyer that while you had the property in your possession, you paid the bills. You're not warranting anything that beyond the time that you own the property. That's a special warranty deed. We're talking about here a general warranty deed. There are no limits set, including time limits. Okay, so let's just move on to our next question. The question is, why have real estate license laws been put into effect? A, to protect licensees from lawsuits. B, to protect the public and establish a standard of competence. C, to prevent licensees from engaging in profit-making activities. And D, to establish maximum levels of competency and the moral marketplace. If you need more time between questions, feel free to hit that pause button. The answer here is to protect the public and establish a standard of competence. Real estate license laws protect the public by ensuring a standard of competence in the real estate industry. Okay, moving on to our next question. All of these are requirements for independent contractor status used by the Internal Revenue Service, except most brokerages hire real estate agents as independent contractors. When your broker pays you, they don't withhold taxes. We get paid the gross and pay our own taxes. All of these are requirements for independent contractor status, except the individual must have a current real estate license. That's A. B, specific hours stated in a written agreement, like hours that they work. C, a written agreement that specifies that the individual will not be treated as an employee for tax purposes. And D, a substantial portion of the individual's income is based on sales production rather than hours worked. You see these accepts in these questions a lot. It makes it harder to answer. Which of these are not required is what we're asking. And your answer is B, specific hours stated in a written agreement. The real estate broker may require an employee to follow rules, such as working a certain number of hours, but the broker may not do so if treating the affiliated sales associate as an independent contractor. By treating you or calling you an independent contractor, your broker can't tell you you have to work these hours. You have to wear a tie every day. You have to be at the sales meeting this Thursday. They can't tell you these things because you are an independent contractor, much like the subcontractor in the construction business. We're still supervised by our brokers, but it does put limitations on how they can supervise us and what they can ask us to do. Even if a consumer has requested placement on the National Do Not Call Registry, a real estate professional may call the consumer up to how many months after the consumer's last purchase? A, 3 months after the last purchase. B, 6 months. C, 12 months. Or D, 18 months after the last purchase. And your answer is answer number letter D, 18 months. A real estate professional may call consumers with whom there is an established business relationship for up to 18 months after the consumer's last purchase, delivery, or payment, even if the consumer is listed on the National Do Not Call Registry. If the consumer specifically asks the company not to call, then the company must stop calling. But without that, up to 18 months. You've done business with this person. You've helped them buy a house, sell a house, rent a house. If you've done business with this person, it's 18 months. 3 months from a consumer inquiry. Our next question. An individual, very good question by the way to know, an individual who is authorized and consents to represent the interest of another person is A, a customer, B, a principal, C, an agent, or D, a facilitator. And your answer is going to be an agent. The agent is hired by the principal. The customer or facilitator is a third party, but that's a very good definition there for an agent, an individual who is authorized and consents to represent the interest of another person. There is legal obligations that go along with agreeing to represent somebody and be their agent. And in most states, that doesn't happen by accident. It requires a written agreement to form that representation. Okay, so our next question is going to be, a broker represents a seller, but is currently working with a buyer to find a home. Assuming that no statute has replaced the traditional common law of agency, which of these correctly identifies the parties in this relationship? Represents the seller, but is working with the buyer. Again, I'll give you a few more seconds on this one. And your answer is going to be D. The broker is the seller's agent. The buyer is the customer. We work with the customer. We work for the buyer, the client. We work with the customer. We work for the client. The client is the party that I've agreed to represent. The customer is the unrepresented third party. But I can still refer this customer to a lender to be approved for a loan. I can work with this buyer or this buyer customer, but I just can't give them advice and counsel. Only our clients. Understand that concept. Next question. The agent's obligation to use skill and expertise on behalf of the principal arises under which of these common law duties? If you remember our acronym, COLD AC, the common law duties of an agent: care, obedience, loyalty, disclosure, accounting, and confidentiality, with the acronym COLD AC to help us remember. Which one of those duties requires the agent to use skill and expertise on behalf of the principal? That would fall under the duty of care. Care requires skill and expertise, using your education and training on your client's behalf. Obedience requires following lawful instructions. Loyalty is putting the client's interest above the agent's, and disclosure refers to material defects of the property. Care is the answer, A. So our next question. A house built over a ditch covered with decaying timber, or a house with ceilings that are improperly attached to the support beams, neither condition being visible yet, are examples of A. Stigmatized properties, B. Environmental hazards, C. Latent defects, D. Conditions that need to not be disclosed. And your answer is going to be C. Latent defects. A latent defect is a hidden structural defect that would not be discovered by an ordinary inspection. That could cause harm to the occupants. And in most states, the seller or the seller's agent is required to disclose latent defects, hidden conditions that could not be discovered by an ordinary inspection. Next question, moving right along. Every state has a mandatory agency disclosure law that stipulates A. How an applied agency may occur, B. When, how, and to whom agents must reveal for whom they provide client-based services, C. Restrictions on disclosure of confidential information, and D. How a customer may be indistinguishable from a client. And your answer is going to be B. When, how, and to whom agents must reveal for whom they provide client-based services. Mandatory agency disclosure laws now exist in every state. In addition, state laws may require a particular type of written form be used and may require that all agency alternatives be explained. A very important part of agency laws that we need to be aware of. Mandatory agency disclosure laws now exist in every state. When we discuss a property with an unrepresented buyer, we have to make sure that buyer understands that now we're not representing them, we're representing the other party in this transaction. We always disclose who we represent to the unrepresented third party. Next question. In a real estate sales transaction, who is the agent's principal? A, the seller, B, the buyer, C, the person who pays the commission, or D, whoever hired the agent. I know what you want to say, whoever pays your commission, but that's not the case. Whoever hired the agent. D. The most complete answer is whoever hired the agent. That could be either the buyer or the seller, but payment of compensation is not the determining factor. The source of compensation does not determine agency. You don't necessarily represent the party who pays your commission. In a normal real estate transaction, the buyer's agent is paid by the seller. Isn't that odd? You're getting paid to represent the buyer against the seller, but you're being paid by the seller. The source of compensation does not determine agency. Moving right along with our next question. Next question. A house was the scene of a drug arrest and a violent murder last year. When it was listed on the market, many people considered it to be A, latent property, B, a stigmatized property, C, damaged property, or D, property with a material defect. I think you know this one. Your answer is stigmatized property. Presuming that the property is physically intact, the drug arrest and violent murder may create a psychological reaction to the property, rendering it stigmatized. Check your state laws. Every state has different laws regarding stigmatized properties. Moving on to our next very important question to know. Shortly after closing on a real estate purchase, the buyer discovered that there were serious flaws in the title that made it unlikely that the property could be resold in the future. What can the buyer do now? A, because the title was flawed, the buyer can legally void the sale, and the seller must return any consideration, which is the money, usually. B, the buyer has no recourse. C, because the seller conveyed unmarketable title, the buyer is entitled to a new title report. Or D, because the buyer has accepted the deed, the only recourse is to sue the seller under any covenants combined in the deed. Well, I had a student recently, she had a theory. Her theory was the longest answer is usually the right answer. And we found that to be correct in most cases, but I don't think we should always go with that. But in this case, it is the case. D, because the buyer has accepted the deed, the only recourse is to sue the seller under any covenants contained in the deed. You know, when does a buyer officially own the home? At closing, when we have delivery and acceptance of the deed, the buyer now owns the property. So if they've accepted a deed with flaws in the title, they own the property. Their only recourse would be if they had any covenants providing them protections in that deed, such as the general warranty deed has all those covenants. It's the best for the buyer because it contains the most promises or covenants. Next question. A history of all recorded liens and encumbrances is revealed in the A, title insurance policy, B, unrecorded documents, C, the chain of title, or D, the abstract. And the answer is D, the abstract. The title insurance policy lists coverage and exceptions to the policy. Unrecorded documents have not been examined. The chain of title traces ownership. The abstract is the most complete documentation of recorded liens and encumbrances. The closing agency hires an abstractor. That's the person profession, an abstractor. The abstractor goes down to the city or the county and they search all these different areas of records to find out what liens are on the property, to find out what the status of the seller's taxes are. They go to the courthouse to see if there's any judgment liens against the seller. All that's, could affect ownership. So this report they put together to bring back to the closing agency is called an abstract of title, the abstract. The reason the deeds and liens and other claims are recorded is to give A, constructive notice, B, actual notice, C, direct notice, or D, nominal notice. Why do we record down at the city or the county? Is to give constructive notice. The recorder's office is a central place to deposit and discover information. Mom passes you down the family home. You don't need an attorney for this. You can go to the office supply store normally and buy in their legal form section, buy a quitclaim deed where mom can just fill out that quitclaim deed and transfer ownership to you. But you do want to take that deed down to the city or the county to record that deed because in the future you might want to sell the property or borrow money against it and they're going to check down to the city who owns the property. So you want to let people know. We record down to the city or county to give constructive notice, to let people know. That way a buyer doing due diligence will discover this information. Constructive notice. And here we go. A person who is designated by the principal in a broad range of matters related to a particular transaction or activity is A, facilitator, B, special agent, C, designated agent, or D, general agent. And your answer is going to be D, general agent. A general agent has a special power. They can sign on behalf of their client, and they can bind their client. A property manager is normally considered a general agent. That's the type of agency property management is, general agency. Is it not the property manager who normally signs the lease? By signing the lease, they're binding the owner to the tenant. The relationship of broker and sales associate is normally a general agency relationship. When you go take a listing, in most cases, you don't have to have your broker sign that listing. You sign the listing agreement binding your broker to the seller, which is the power of a general agent. Let's see what they have to say. A special agent is given limited authority for a limited time. A general agent is given broad authority in a specific circumstance. A property manager is typically a general agent for the owner, as are most real estate sales associates for the employing broker. Okay, our next question. All of these are violations of federal antitrust laws, except A, group boycott, B, allocations of customers, C, commission splits, or D, tie-in agreements. And your answer is C, commission splits. Nothing wrong with splitting commissions. Brokers may legally share and split commissions. Price fixing, allocations of customers, and a group boycott are illegal under antitrust laws. You might remember that the most common form of antitrust violation is price fixing. Competing brokers getting together with an attempt to establish a standard commission rate. Can't do that. Okay, well, moving on to our next question. All of these are ways for a broker to charge for services except A, a standard community rate, B, a flat fee, C, an hourly rate, or D, commission based on a percentage of the selling price. And your answer is going to be standard community rate. There is no such thing as a standard community rate. That would mean the brokers got together and standardized the fee, which would be an antitrust violation. Under antitrust laws, brokers may not collaborate and agree to charge the same rate to customers. Brokers may charge for services using a flat fee, an hourly rate, or a commission based on a percentage of the selling price. There is no thing as a standard community rate, though. If you found this video helpful, please give us a like and subscribe. Don't forget, click on the bell. That way you'll be notified when we upload part 3 of our series, the 75 most important questions you need to know to pass your state's real estate licensing exam. Thank you.